Please be seated. Good morning. Welcome to the First District Court of Appeal. We have one case on the docket today. It is Michael Jackson and Florida Medical Clinic versus Florida Birth-Related Neurological Industry Compensation Association and Dr. Boysch. So that's case number 230269, and we've allotted 15 minutes per side. And counsel, you may proceed when you're ready.
May it please the court, Dinah Stein on behalf of the appellants, Dr. Jackson, Dr. Piniello, and the clinic. And as we've advised the clerk that we have requested 5 minutes for rebuttal time, if it pleases the court. Thank you. And we're here today, obviously this is an appeal from a final order of the administrative law judge in a NICA action, and we contend in large part that this issue of notice comes down to the proper application of section 766.316 when no acknowledgement can be shown that NICA notice was given. The acknowledgement is a discretionary option for medical providers in the statute. They may provide that to the ALJ, and in return they get a rebuttable presumption. We obviously lost that rebuttable presumption when we couldn't produce a signed acknowledgement. So the next question is, how much weight does the ALJ put on the absence of the signed acknowledgement when all other things being equal show almost unequivocally that and I say almost because we do have this, what we say is unreliable testimony, but almost unequivocally from medical records and consistent testimony that NICA notice was given. And I'll start with what the ALJ had in front of him. He had testimony, of course, from the medical assistant. This was Amy Harmon, who was the person who was responsible for notice. And she went through in detail how she would ensure that patients got the complete educational materials when they were designated as pregnant and became OB.
But she said she had no independent recollection of giving the notice, correct?
That is correct.
But she said that this is my usual practice. I have the whole packet for every patient, and I do this. And this is my usual practice and custom, right?
Usual, yes, absolutely.
Okay. And so on the other side, we have the mother saying, I didn't get it. So we have conflicting proof, and the administrative law judge has had to do what judges often have to do. They have to weigh conflicting evidence and find which one they think is most credible, correct?
That is their duty, and to be clear.
And that happened. And so it seems to me that, the issue is whether there's clear and convincing evidence to support the finding of the ALJ. And so it seems like you need to show me where there was not clear and convincing evidence, but it seems like there was evidence on both sides. So.
And thank you, Your Honor, and that's what we're here for. And I agree with Your Honor, that is his duty, and we're not asking this court to reweigh anything. What we're saying is that the ALJ, and if you look, I think it was paragraph 32 of the order, says that the absence of the proof of confirmation acknowledgement raised significant doubt. And that's, I want to just kind of hone in on that because to show the difference in testimony regarding being able to prove it and the testimony and evidence that notice was given. First of all, and
certainly if you'd have found a signed document, that would have given you a presumption that was a rebuttable presumption, but one that would be pretty hard to rebut.
There's no question that we, by being unable to produce the acknowledgement, lost the rebuttable presumption. I want to just compare, though, the evidence of scanning the signed acknowledgement to the other evidence, because I do think that's an important distinction that got lost in this. The evidence that was so unequivocal, and we have 3 entries in the medical record from January 6, contemporaneous, showing that NICA notice was given, including the doctor and the medical assistant. We had the unequivocal testimony from the medical assistant who said 100%, if that was my patient then, which this was, she would have gotten the NICA notice. We then have testimony from Dr. Roller, who said, I would not have checked anything that we didn't go over. because that would be something I would discuss with the patient another time. And she even wrote a typewritten note that educational materials were gone over. What's absent from the record is how the actual signed acknowledgement made it into the electronic medical record, because that's really the problem, is there's allegedly, there is what we contend a signed acknowledgement, but nobody testified that the process of getting that signed acknowledgement into the electronic medical record was in fact, there was really no testimony at all other than some testimony that it would be done at the front. The front office would take care of that. So we do know that. The Dr. Roller would take the materials to the front office, give it to them, presumably to scan, but there's nothing in the record to show that if something didn't make it into the record, that indicated notice wasn't given. And that's the disconnect, we contend, is that the ALJ said, this raises significant doubt as to whether it was even done. And in this case, it didn't have the same.
When a pregnant woman goes in to talk to the obstetrician, there's a big packet of stuff that's given to her, and the person goes through several different things, correct?
Correct.
Okay. So, even though these packets are put together and they're all supposed to contain all the documents, it could happen that the person putting the packet together missed this document, didn't put it in there.
That is possible.
Okay.
And that comes back down to, what is the evidence that the ALJ, the ALJ can't simply determine that because it's possible that something didn't happen, it happened. I think there has to be still competent, substantial evidence.
Which actually leads me to a question. When I read paragraph 31, which I have done a few times now, and I'm trying to piece it together, how exactly did the hearing officer here weigh the evidence, weigh your witness's evidence against the patient's evidence? How was that done, and how did they reach the conclusion that notice was not provided? Because that has to be a factual conclusion that they reached.
Right. He found, it appeared to be that he found all witnesses to be credible. I don't think he thought anybody was not telling the truth. He acknowledged that Ms. Boyce had an imperfect memory, and I think reading that order, it looks like it came out to a wash because it was 7 years ago. He acknowledged that memories were not perfect, and he seemed to give a lot of, I'd say, weight to Ms. Boyce's testimony, which we contend has to be taken in context of the rest of her testimony, where she said, granted, she did say, I didn't receive the NICA notice. She also couldn't remember major parts of that day.
But that's the thing. I don't see anything about, just the one sentence that she testified she didn't receive the notice.
Right.
In 31, which is the only paragraph in this entire order where the judge actually makes an attempt to weigh the evidence and to come to a conclusion. It seems to me that there's not any weighing going on here, that it's just simply saying that, well, this happened and I reached this conclusion based on this. Was the testimony actually weighed in your opinion?
I don't believe it was. I think that comes through from the order, is that this, he doesn't do any weighing, then just talks about this one, statement from the plaintiff, the claimant, and then says, and by the way, your inability to show signed acknowledgement raises significant doubt. And I think, that's not weighing at all. That is really disregarding the medical records.
Well, why can't that raise doubt? If you have testimony about what the process is, this is how it works, this is what we do, we provide the form, and then we scan it and put it into the record, and it's not there, why can't that be reasonable evidence to draw an inference that it wasn't done? Because it's not the way they say the standard process works. It apparently didn't happen here.
I think if someone came in and testified in the proceeding that 100% this was the process for how we had things scanned, and the scanning was consistent with giving NICA notice, that might raise an inference. I mean, that I think would raise the doubt. But here that's where the process seemed to just not be as reliable as giving the NICA notice, was getting it scanned into the record. And there's no testimony that is similar to the other testimony about the scan process. That's where I think that's a problem, is that we don't have testimony that making it into the electronic medical record had the same reliability as what Ms. Harmon said was 100% reliability as far as giving them the notice. I mean, she said if I was there, and she was, they got the notice. Yes, Your Honor. I was looking at my time, but I would like to ask any questions.
Well, you're into rebuttal time. You can reserve the rest of this, or does anybody have any questions?
I would like to reserve the rest of this for
Okay.
rebuttal time. Thank you, Your Honors.
Good morning, may I please the court? Brian Lee representing Mr. and Mrs. Of the child in question. And we are co-appellees here, and we're going to split our time if the
Okay.
court is, pleases the court. So I'll try to keep track of that.
Okay,
So
yeah, you need to keep track of that, and you
I
can split it
think-
any way you want to.
we were definitely told. So what we have here, Your Honors, is a final order from an administrative law judge doing what an administrative law judge was supposed to do statutorily under this statute. This statute says very clearly that there is a rebuttable presumption if the provider provides a signed form. That was not done. And so what occurs at that
Well, certainly
point-
that's the standard. If there's a signed form, there is a rebuttable presumption that notice was given.
That's correct.
But what about the ALJ's statement that along the lines of, because there was not a signed form, that calls it into question? It seems like maybe he thought there was a presumption that went the other way in the absence of a form.
I don't think so, Your Honor, because once that presumption is gone, then in this case, appellants have the burden of proof. That's very clear. And then the fact that there was no form that was presented does not just vanish, meaning that neither side can't use that anymore in their evidence. That becomes just another piece of evidence that the ALJ can use in determining whether the appellants present their burden of proof. And here's why. Because the appellant's argument in this case is that we told her, but not that someone says we told her, or we gave her this notice, I saw the signature. It's that our policy and procedure is this. It says that we do it all the time. And then our medical records say, well, the NICA form was given and signed. But then the issue becomes, okay, well, they don't have a form. And so the ALJ can look at those, and he did in his order. He says that the fact that they're saying on one hand that they give it every single time, we sign it every single time, we never check the box or put the form in there if it isn't signed, but then they can't produce the form, the ALJ can weigh that to determine credibility.
So you acknowledge, of course, that the form is not legally required.
That's correct.
Okay, so if you have a physician who just doesn't have a policy to have an acknowledgement form at all, what would satisfy their obligation to establish that notice was given? Say it happened a few years ago, like in this case.
can
What
have
exactly would be satisfactory? Because it doesn't seem to me
Sure.
that the judge had to kind of a circular approach to, well, because there was no acknowledgement form, which is undisputed, I find that fact means that they didn't provide notice.
Well, I'll answer your question, Your Honor, but I wanted to, the last part you said, It wasn't just that Ms. Bosch said that there was no form. There's more evidence to it that led to it. Ms. Bosch said, of course, that she didn't sign the form, but as the court, and I know you were looking at paragraph 31 in the final order.
Did she
but-
say she didn't, I'm sorry to interrupt. I'm going to ask a third question here.
Sure.
Did she say she didn't sign the form or that she never received any notice?
She says that and let me just make sure, she testified that she was not provided a brochure or a folder of materials during that visit. Okay, so she wasn't provided anything.
Right.
So, I mean, I guess the conclusion is that she didn't sign anything either, but, so she wasn't providing any information at that visit. That's her testimony. It's not just that there is no form that's there. And so when we look at what then the appellants say they provide, it's not just, and this is in the record, it's not just a couple of forms that they have, the NICA form, the brochure, other types of forms. One of the things that I noted when I looked at this that they supposedly provide during this in the packet of forms is a 460-page book, supposedly, that they give to every person that's there. And so all of this evidence was in front of the ALJ. And so for the ALJ to say, for the appellants to then say, we provided everything to her, and then for Ms. Bosch to testify very specifically that I wasn't provided anything, any documents, any brochures, the court could weigh that evidence together. Now, the fact that the court said that because the form wasn't there, it is another piece of evidence that they're saying that the form was signed, but they don't have the form. So a court can draw inferences from the facts of the case. The fact is, Ms. Bosch says, I wasn't provided any documentation. The inference from that is that there was never a form there for me to sign, and I never signed it. So the court can draw those types of inferences, and that's perfectly plausible to draw in this case. And so when you're looking at the findings of fact and the conclusions of law, they do bleed into each other in some way. But the standard for this court is whether there was competent substantial evidence to support the ALJ's ruling.
So we apply that regardless of what the hearing officer actually said, that if there's something we find in the record that supports it. I mean, this isn't a judicial officer here. Shouldn't we just be relying on what the ALJ actually ruled on instead of just searching the record for evidence that supports the conclusion?
I think that's the standard. Competent substantial evidence is the standard. Both sides have agreed to that that's the standard for this court to look at. And so, where's the line drawn between competent substantial evidence? Both sides have tried to define it as the cases have, but it is a situation where at the end of the day, the ALJ has differing evidence in front of it, and it is exclusively his province or her province to weigh that.
Okay.
And in this case, he did.
Let me go back to the first thing I asked, which is, it just strikes me that the evidence that the medical people here produced is exactly the kind of evidence that one would produce if they did not produce an acknowledgement form. And it was really kind of disregarded out of hand, saying that, well, it's inconsistent with the fact that there was no acknowledgement form, so it's insufficient. So my first question, of course.
Right, and I'm sorry
I
to
asked plenty of, that's okay, I asked plenty of them. What evidence would be sufficient beyond what the physician did in this case?
Sure, I think there are cases, and I apologize for not knowing in particular, but there are cases that talk about if a form's not there, but the doctor or a physician, whoever does the form, says yes, she signed the form, or has equivocal testimony like that, and then the plaintiff, I guess really the claimant at that point, can't rebut that. And so there is a situation where you can have testimony, not just the form, but testimony that we did this or I remember doing this, and the claimant can't say otherwise, can't say, no, you did not. So there is evidence that's not just a form that a provider can use, and I think they've done it in the past. It's just in this case that they had no one to say that, and the only thing that they could say is, well, our medical records say this, That's what we say. But they had equivocal testimony, or the ALJ had equivocal testimony from the other side that says that did not happen. And so that's when his weighing of evidence hat comes on. That's what
So
he
what
did.
would, what would happen if the doctor's people said, we can't find the form, but I remember handing her the brochure.
Mm-hmm.
And the mother's testimony was, I don't think I got a brochure.
Okay.
I don't remember whether I did or not. Well, what would happen then?
Then the ALJ would weigh that evidence. And at the end of the
So
day.
which way do you think he should weigh that? What would you think would be the appropriate ruling there?
I think we could have gotten the same ruling we have here, because the ALJ can assess credibility of witnesses. That's what the ALJ does.
But he said he found everybody credible. You know,
Sure.
the-
No,
the
I
only-
and
The
I
only
understand
reason
that.
that wouldn't be good evidence on behalf of the doctor's people if they were lying or fabricating or something.
True, but this court, I think it's this court, and it might be the second DCA, said that the ALJ's decision could be based upon one witness's testimony, to the exclusion of everybody else. And so this is not a situation, I think, where where there is this sort of almost scale where four witnesses and say this and one witness says this, well, then that means that the ALJ has to rule in the favor of a medical provider. It's the classic weighing of evidence, and the ALJ is in the best position to do that.
So
And so even in that
your basic
situation,
argument is both sides came forward with credible evidence, but the burden of proof was on the other side. So
Correct.
They didn't prevail.
that's right.
Okay.
I'm going to rest of my time for my counsel.
May it please the court, I'm Tana Story with the firm of Rutledge Asenia here on behalf of NICA. And in this appeal, NICA is in somewhat of a unique position. We're essentially here to help with the consistency of the interpretation of the plan. The factual issues of notice are really between the healthcare providers and the parents. NICA would agree with the appellants that the acknowledgement form is not required. It is not a legal requirement for notice, only the handing of the peace of mind brochure.
Certainly helps, though.
Excuse me?
It certainly helps, though.
Yes, it certainly helps. Yes, the rebuttable presumption would have changed this case. But we also agree with the appellees that the standard of review here is whether there's any competent and substantial evidence in the record to support the ALJ's determination. And we think he weighed the evidence, and we would ask that you affirm the final order. Any questions?
Thank you.
Thank you.
And may it please the court, I'm just going to pick up with something that counsel for the claimant started with, and that is, the shifting burdens once the medical providers lose their rebuttable presumption by not producing the acknowledgement. If this was just a clinic that, let's say they had no practice of keeping the acknowledgement or even getting a signature. They would give the NICA notice, they would give, the participant notice, and that was their practice. Then that would be it. The ALJ would weigh the medical records and the testimony, and the absence of a form wouldn't come into play at all. But because this was a clinic that, should have and sometimes scan the forms, the absence of the form transcended now a lot of this unreliable testimony that the ALJ, I guess, just accepted. If you go back to the Ms. Bosch's testimony, first she couldn't remember receiving, she said, no, I didn't receive any forms at this visit. Then she couldn't remember if she ever received forms from the clinic. And, it got to the point where it was just implausible that in light of the medical records and the testimony, that somehow this comment and then the absence of a form would somehow become the paragraph 31, essentially, which is the ALJ's finding.
So if there's a signed form, there's a rebuttable presumption, correct?
Correct.
And so your argument is that in the absence of a signed form, the parties should have been neutral. They should have been standing on equal ground.
That's correct.
But in the order of the ALJ, he seemed to think that the absence of a signed form had some evidentiary value that put them on a stronger footing than you.
Exactly.
Well,
Now,
who has the burden if there's no form?
if there's no form, the burden is on the medical provider.
Well, isn't that, so there is at least some weighing done, because the burden is on you to start with.
If the weighing was done, then, I'd submit we wouldn't be here. Our position is that the weighing was not done, and the absence of a form just transcended, again, contemporaneously taken medical records and very consistent testimony from numerous witnesses that all corroborated how the process worked, and that the forms not only would have been, but were in fact given to the claimant here. And that's really the position, is the absence of the form can't transcend any of this, because, again, absent some testimony that the form would have always been scanned into the medical record if notice was given, which we don't have here. So that is exactly our point, is that it becomes a zero, a neutral. The ALJ goes back to just weighing the evidence and testimony, and here the competent substantial evidence just does not support the finding that the NICA notice was not given to the claimant. So we would ask for your honors to reverse. Thank you.
Thank you, counsel, on both sides for your argument. It was very helpful. We have no other cases before us, so we are adjourned.
All rise.